Good morning, everybody. Thanks for joining us today. My name is Guy Grant. I'm a senior solicitor in the retail and leisure team within Brodie's real estate team here in Edinburgh.
And nice to meet you all. My name is Stuart West. I'm a solicitor in the real estate team in Edinburgh as well.
So, operations when negotiating and documenting lease concessions relating to COVID-19. This will include implications for rent abatements, turnover rent, keep open obligations, rent-free periods, and service charge. We're also going to bring in some examples of the emerging commercial practice that we've seen from our wide range of landlord and tenant clients. Brodie's are quite uniquely placed in terms of the breadth of our property practice and the depth of experience that we have available to us to react to these kind of new and novel and major challenges such as COVID. So we hope you find today's presentation useful and it gives you a bit of insight into how we've been helping clients get through the pandemic. So can we just pop on to the next slide? So why this topic? Coronavirus has been the biggest shock to the property sector that we've seen for decades. And as we see the rollout of vaccines and some positive signs that we're heading towards lifting restrictions, we wanted to look back at what landlords and tenants have been doing to deal with this challenge. We should provide some context for what the responses might be to some future events with a sort of similar practical outcome. Fingers crossed we don't have to deal with anything like that anytime soon. First thing to point out here is that there's no one-size-fits-all approach for landlords or tenants. When it comes to dealing with the consequences of the pandemic, the consequences will vary hugely depending on a broad range of factors, including the parties, the size, their sector, and their geographic location. Brodie's operate for a huge range of clients across a wide range of sectors, from supermarkets to the big discount retailers to major high street brands, major chain restaurants, fast food chains, luxury brands, and some independent operators. So we've seen the full range of responses in the market. So, for example, from the tenant perspective, supermarkets and the big discount retailers have been the obvious winners, if you can say there have been any winners, whereas those tenants that are working in sort of the non-essential sectors and those that necessitate sort of physical interaction with their clients, such as barbers or hairdressers, will have had a much worse time. From the landlord perspective, their size and the diversity of the locations and their tenant mix have been a really key in determining their resilience to economic shocks. So I think it may have been lost on some tenants at the start of lockdown, especially for smaller landlords and those with significant repayment obligations in terms of their own lending, that they may have been in a much more perilous situation than would otherwise have been appreciated. We also haven't seen the same level of support for landlords that we've seen for tenants through, for example, the furlough scheme. So the biggest challenge that we've seen for landlords and tenants in terms of their properties has been how to balance lease obligations against the negative impacts of lockdown and the pandemic. We've seen the emergence of a new form of lease concession, which is specifically related to pandemics and epidemics. One major theme that we've seen coming through all of this and what's made them successful has been early engagement between parties, and constructive and ongoing dialogue has been absolutely key. So having the sort of open and honest conversations about how the pandemic is affecting business has allowed a lot of our landlord and tenant clients to find sort of mutually beneficial and commercially acceptable positions. So what we're going to talk about today is the specific challenges that key lease obligations pose in the context of a pandemic and a lockdown, some of the options for landlords and tenants in terms of negotiating concessions to address these, and some of the pitfalls to avoid when considering lockdown and pandemic provisions. So what are the key issues arising from the pandemic and lockdown? Firstly, everybody wanted to know if tenants had to keep paying rent and service charge. Those are the biggest, or at least two of the major drivers of costs for tenants, and they are the largest source of income for landlords. Secondly, as the furlough scheme kicked in, and even before that, where tenants had elected to close, and when footfall numbers were plummeting, some tenants wanted to know if they had to keep their shops open or if they could shut. The operating costs and staff wages of keeping units open are another major driver of cost for tenants. Some tenants were more concerned about retaining the ability to stay open in the early stages of lockdown, and so we given clients advice around that. But those operators were really quick off the mark in terms of understanding whether or not they were an essential retailer and kind of what their position would be. It's become clear that the real sticking point between landlords and tenants has been around permitted closures and the enforcement of keep open obligations. Thirdly, and this is probably the most thorny issue to resolve, tenants wanted to know what concessions landlords would give and where the market was heading in terms of a standard response to the pandemic. From the landlord perspective, they've been looking to find the right balance between dealing with tenant demands. On the one hand, they want to maximize their rent collections, but on the other, pushing tenants too far could result in being unable to pay, or in the worst case scenario, even heading towards an insolvency situation, which everybody wants to avoid. Another aspect that landlords have had to consider is that tenants might feel that landlords are being unfair or unreasonable if they take an uncompromising position, and that could push the tenant to take an uncompromising position themselves as they feel sort of pushed into a corner. That might end up resulting in stopping paying rent in an attempt to push decisions into the landlord's court as to how to deal with the pandemic. I suppose before we get into the detail of this, it'd be worthwhile just defining what we're talking about when we say lockdown for the purposes of leases. Stuart's going to go into this in a bit more detail later on. But it's worth noting that these provisions have been sort of aggressively negotiated in the last year, and we're starting to see two main forms of defining a lockdown. The first is where a tenant is legally unable to open to the public. So that would be as a result of legislation or from regulations. And the other version is where tenants could legally open, but it's against a guidance from the government or a local authority or the NHS. There was originally a third option that we'd fought for a number of clients, but we really struggled to get traction on it, and that was where, as a result of regulation or guidelines, trade would be detrimentally affected, or where the tenant had elected to close on the grounds of health and safety of their customers and staff, and that's just proved to be a step too far for a lot of landlords. So, rent and service charge. Leases are there to govern how parties act towards one another and to regulate that relationship between the owner and occupier, where a wide range of issues arise. So the particular problem with the pandemic was that it resulted in circumstances that very few leases had catered for. We can contrast this with standard lease provisions in damage and destruction, where the lease provides that rent and service charge would be suspended for a period of time or until the tenant can occupy again. However, it's clear that this isn't the case for the pandemic, as it hasn't resulted in physical damage to buildings, so parties can't rely on provisions like that to resolve the issues here. So what can they rely on? Leases all have a provision requiring tenants to comply with statutes and acts. So if a tenant is legally prohibited from opening, such as in the case of a hairdresser or a barber at the moment, then how do we balance this against the obligation to pay for the right to occupy a property, being the rent? Surely we can't expect a tenant to continue to pay rent and service charge even though they're legally prohibited from occupying and using and enjoying the property for carrying on their business. The pandemic has thrown up this situation that just hasn't been in the contemplation of many landlords and tenants. As you'll have seen from the news and from speaking with clients, if tenants haven't been able to open and trade through lockdown, they'll have had significantly reduced incomes, and many will be feeling the financial strain after such a long time without a regular income at their normal level. And so their desire and sometimes their ability, unfortunately, to pay at the same rate as normal during regular times has been seriously challenged. There were very few instances where landlords and tenants had thought about this specific issue previously and provided for rent abatements or reductions in this type of scenario under the current terms, other than to some extent within turnover provisions, and we'll touch on that. So what are the options? Tenants could pay in full. This is the simplest way for a tenant to avoid a conflict with the landlord, just to keep on complying with their lease obligations. But as we've just discussed, this isn't always financially possible. It's a great solution for a tenant whose cash flow doesn't come mainly from retail sales. For example, some of the mobile phone providers, O2, EE, Vodafone, and their cohort. But it doesn't, most of their income will come from their monthly subscribers. But it doesn't really work for your local barber or your nail salon that needs to have somebody in the premises and actually paying them to carry out some services. Another option is to not pay. Withholding rent isn't something that we'd ever recommend tenants to do. But to some extent, I suppose the fear of not paying rent has reduced. Firstly, and initially because the extension of the time period for irritancy being pushed out to 14 weeks. And secondly, for many properties, and I think this is really the core issue, is that the commercial reality of who else is the landlord going to be able to get to take on a unit in the middle of a pandemic. Now, this view might start to change quite quickly if we see a continuing fast rollout of vaccines and we see consistently low levels of transmission through the population, even as restrictions are lifted. We'll just have to wait and see what happens on that front. A few of our clients have elected to take this option, but that's generally been a short-term solution to avoid an immediate financial crisis. For example, restaurants, but before the Eat Out Help Out scheme, they were going through a bit torrid time as they'd had no income for a while. And this was before they'd created or worked out how to expand their delivery options. So some of the big restaurant chains were really struggling with cash flow and so elected not to pay. The consequence of that is that there's going to be a significant chunk of arrears waiting for them at the other side of lockdown. And so arrangements are going to have to be put in place to deal with that. Another option for tenants is to pay a bit less. Actually, quite a number of clients have elected to take this option, including some of the major high street operators. It's not been necessarily every location, but just where it's been relevant to their business. And while this isn't something we'd normally recommend, it has bought some clients some goodwill by showing willing to continue to pay at least a portion of what they owe, when some of their neighbouring operators have elected not to pay or couldn't pay. So the final option here is concessions. This is the most balanced option in terms of putting in place a negotiated concession. We've seen a huge range of concession options for rent and service charge. Some of the more powerful tenants, those with stronger covenants, have been able to push for abatements of both rent and service charge. Mainly these have been sort of partial abatements, but we've seen as high as 50% throughout a lockdown period or during any guidance recommending self-isolation or lockdown, and covering future pandemics and epidemics. When it comes to smaller tenants or those with a lower or less strong covenant, they might have struggled to get those kind of general concessions and leases where the basic rent would be reduced in the event of a lockdown. But what we've seen is a lot of personal concessions which are time limited for either this lockdown or this series of lockdowns in respect of COVID-19. When looking at these concessions, key factors to consider are how much of an abatement there's going to be, how long it's going to last, any repayment obligations after the lockdown, and how to deal with any arrears that might crop up as part of the response to the pandemic. Many of the personal concessions have been working on postponed payments for a portion of the rent for the lockdown period, and we've seen these again as high as 50%, but with payback options over 3, 6 or 12 months after lockdown ends. So there's also a point to make sure that definition of when the lockdown ends is really carefully defined so that you don't have another lockdown and then a tenant needing to continue to pay. I suppose there are also got to take into account that lease events such as break options or expiry dates will affect how these are negotiated. We've seen many tenants sort of negotiate retrospective rent reductions. Some are even achieving discharges of arrears liability. It's not quite as common, but we have seen it for taking on new deals. And we're seeing a lot of short-term extensions at the moment with landlord break rights being inserted. And in some instances, we've seen this leading to tenants feeling a bit more empowered to push for a more punchy commercial deal on the basis that if the landlord doesn't like what they've agreed in practice, they can exercise the break, which is an interesting take. Some of the pitfalls maybe to avoid when looking at these kind of provisions. Landlords and tenants should be careful about what they want to happen if we go in and out of lockdowns. When to consider whether the concession applies just once to a single lockdown, or if it's going to continue until COVID is no longer considered a pandemic. We should also consider if these are going to be one-off concessions or if this is a longer-term change to lease provisions. And we need to understand whether they'll apply in any future lockdown or pandemic. That would certainly be our preference. As we've seen, clients have had to do all the hard work in negotiating these terms, which we then documented for them and assisted them in. But we're seeing a really mixed picture from landlords in terms of accepting abatement provisions as standard. Future reaction to this might well depend on the availability of loss of rent insurance for pandemic situations. And that's one of these things that's going to sort of come to fruition as and when those kind of products become available. We've seen a lot of parties seeking to put in place retrospective arrangements to cover periods where the tenants have elected not to pay or have paid less than provided in the lease. And parties should think really carefully about how this is structured so that it doesn't trigger any interest payments and sums they've just tried to abate. That generally won't be the intention of the parties, but we just need to be really careful about kind of how they're worded. And so if you see solicitors that are working with you fussing over these provisions, it's not unreasonable. Those are usually covered under a separate provision under the lease, and so we need to make sure that we don't inadvertently leave a liability hanging around. Another thing to consider would be rent-free periods. If you're dealing with any new leases or renewals, then it's really important to get any rent-free period protected in the event of a lockdown. Otherwise, the benefit to the tenant can be largely lost if they aren't able to trade during it. For new deals, we'd seek to push out rent commencement and extend rent-free periods by any periods during which the tenant's been unable to open or to trade due to a lockdown. Landlords might take a different approach to this, and so we need to be clear about what happens to rent-free periods in the minute of a lockdown. And it's really valuable to have that set out at the head of term stage. Some sort of international input into this one. There's some precedents for these sort of emergency type scenarios and dealing with rent and service charge and abatements. For example, from New Zealand, they have provisions about earthquakes. So if there's a national or local emergency, which is kind of a widely understood concept, the rent and service and full lease obligations will be postponed just as they would do in a damage and destruction provision here. It essentially just adds on another element to that portion of the provisions. It's not something we've seen here, but it's just an interesting observation from an international perspective. So on service charge, we've seen service charge costs and expenditure generally fall throughout lockdown. Some landlord costs will drop really significantly, particularly where they operate at large shopping centres and they've had to close or mostly close their heads of spend, particularly where those heads of spend are driven by footfall or there to drive footfall, such as cleaning, small repairs and maintenance, security, advertising, promotional events, or even as we've seen in the last month, shoveling snow in the car park. A lot of those costs have been absolutely slashed over the last year. And what that's meant for tenants is the budgets that were set at the start of the year are actually much higher in a lot of circumstances than what's actually now required. So what we've seen is some tenants have sought to limit the obligation to make service charge payments or to defer those payments through Q2, Q3, and Q4 of 2020, and Q1, Q2 of 2021, and potentially even beyond. What we've seen is that some of the major landlords have actually been willing to accept these service charge abatements or deferrals, but on the basis that tenants have already paid some service charge at the original rate for that service charge year. And then the landlord's costs have dropped. And this means that the landlord's either sitting on a small surplus or more likely the difference between what the tenants have paid and the new estimate for the yearly total of the service charge means that any arrears are actually likely to be much smaller than they would have otherwise been if the costs had continued at the original level. As a result, we've seen agreements to defer payments through to the annual reconciliation, which is, I think, quite a smart move, and it's suited quite a number of tenants and landlords. We've also seen some agreements to postpone payments into the following service charge year and spread that cost evenly as either an addition to the monthly rental payments, or just as a new monthly payment, or just adding on to the quarterly payments of service charge. Depending on the level of service charge, we want to make sure that tenants understand and landlords understand kind of that spread of payment to make sure that it's not punitive and it's not overly onerous. One pitfall to avoid when it comes to service charge is that we do see in some older leases that the landlord's obligations to provide services are linked to payment of the service charge by the tenant. This is something that when we're acting for tenant clients that we'd really strongly push against. But it's something we do see in older leases, and so it's something to be aware of as an issue before a tenant was to elect to stop paying service charge without a concession being in place. So that's all from me for this first section. I'll pass on to Stuart now, and he'll be able to take on the keep open provisions.
Yes, thanks very much, Guy. And I can see the slides on keep open provisions as well, so I can get going with that. I think if we look back on the past year or so to the early days of the pandemic, I'd suggest that keep open clauses have in some respects been a double-edged sword. On the one hand, understandably, a landlord's strong preference is for business to continue, so there can be no tenant argument that they are not getting the use of the premises. Early in the pandemic, the UK government and devolved administrations did not actually require premises to close, instead issuing guidance that premises should shut. This proved problematic for landlords and tenants because we had some clients, mainly tenants, who wanted to shut as trade had significantly deteriorated. Other clients, of course mainly landlords, wanted tenants to stay open for as long as possible so that there was no question of rent and service charge being paid, and to ensure that turnover leases continued to operate and generate rents. Therefore, the problem that arose was that government guidance was encouraging tenants to close, whereas lease provisions were requiring tenants to remain open. Fortunately, this issue has hopefully been dealt with as a result of the UK government and devolved administrations requiring tenants, that is, those deemed non-essential, to close. I think before we go any further, it is important for us to define what we are talking about when we use words and expressions such as lockdown, open for business, and trading from premises. As Guy has mentioned, there are two main forms of defining lockdown. One, where a tenant is legally prohibited from opening their premises as a result of legislation or regulations, and two, where a tenant could legally open, but doing so would be contrary to local, NHS, or other relevant guidance. The latter has hopefully now been resolved as a result of government mandating closure for tenants deemed non-essential, and so I'm going to focus on the former, where tenants are required to close by law. Lockdown is certainly one of those words, I think, but prior to the pandemic, it was hardly ever used, but now it's heard practically every day. Despite that, and in particular in a property context, there's no accepted definition of what exactly it means. To explain, we are currently in a lockdown. However, this is a looser lockdown than we saw in March and April last year, when, for example, even construction was halted. Perhaps lockdown should just mean the times that we are legally required to stay at home, as was the case in the lockdown in March and April, and this lockdown. The expression open for business presents its own problems. To what extent do premises need to be open to be said to be open for business? Is a shop that is closed to customers, other than for online collections, open for business? This is a particularly contentious drafting point when documenting concessions. From the landlord's perspective, it would be argued that if a tenant is able to get use of the premises, then they are open for business. It is not within the landlord's control, or indeed the landlord's fault, that the tenant may not be what could be called fully open. Compare this to the tenant's perspective, who understandably would argue social distancing or not being fully open at all to the public significantly affects their use and enjoyment of the premises. So of course they are not open for business as that expression would have been understood prior to the pandemic. To turn to my final example, what does it mean to be trading from premises? In the previous example, where a tenant may be operating, say, a click and collect service, does that constitute trade from the premises? Does it matter where the stock that a customer purchases is stored? For example, in a central warehouse, as opposed to the back of the premises in question? How about the distinction between products collected from the premises and products ordered online, meaning a customer does not have to set foot inside the premises? I hope to show with these examples that there are no settled definitions, and drafts will be subject to significant negotiation to try and reach a favourable position. It's important to bear this in mind when negotiating heads of terms, as even if words used can be interpreted differently, do try to expand on what such words are to mean in your context. Of course, we're not asking you to do the drafting for us, but when we negotiate concessions, the heads of terms are the basis on which we should draft, which means ensuring meanings are accurately captured is of paramount importance. To take just one practical example, the inclusion of one additional different word to heads of terms can allow your solicitor much more leverage when agreeing the concession. The difference between heads of terms providing for the lockdown as opposed to providing for any lockdown is huge. Even if, when heads of terms are being negotiated, no further lockdown is expected. We have seen examples where tenants have received a concession for the first lockdown, that is in March and April last year, only on the basis that the intention was clearly just for a one-off event and not an ongoing concession. In some cases, this will have accurately captured the intention of the parties, but given what is at stake here, I would suggest it's worth being totally sure that the point has not just been overlooked. Considering the practical implications of open for business and trading from premises, it is important when preparing heads of terms that you really consider the tenant, or indeed the landlord's, particular concerns. A concession that is triggered when a tenant is not open for business is of little use if having an online presence and selling your goods online means that a tenant is deemed to be open for business. The same can be said for trading from premises. We are seeing that this is of particular importance for tenants with turnover rents due to the way which the rent may be calculated. This is something that Guy is going to discuss in more detail shortly. Relatively speaking, overall, we have had an easier time negotiating concessions from landlords. Clearly, if a lease is purporting to oblige tenants to stay open where it would be illegal for them to do so, then there is an obvious conflict with, of course, the legislation prevailing and landlords being forced to deal with tenants closing. The particularly relevant point here is whether the tenant is legally able to open. Considering the two main definitions mentioned earlier, you can see how the distinction between guidance and advice, as contrasted with laws, could introduce grey areas. The ultimate question here for tenants is, am I legally required to close? While a majority of tenants may prefer to close to minimize outgoings, as mentioned previously, a minority may rather remain open with COVID secure measures such as social distancing, but are legally prohibited from doing so as a result of government intervention. To illustrate, we are currently in the situation where shops and venues deemed non-essential have had to close, not directly as a result of the pandemic by their own choosing, but due to government laws intervening and requiring them to close. This highlights the conflict with the tenant's obligations, on the one hand, to remain open, as may have been negotiated with a landlord and documented in the lease, but also to remain closed, with standard lease provisions requiring tenants to comply with statutes. In such situation, the law is of course supreme, and landlords are unable to enforce obligations that are contrary to law. If, however, there are no restrictions preventing a particular business from opening, and the lease contains sufficiently specific clauses allowing a keep open clause to be enforced, then courts should enforce these obligations. They will only not do so when it is impossible or in exceptional circumstances where there were good reasons to refuse it, and in particular, if it would be inconvenient and unjust, or if it would just cause exceptional hardship to grant a keep open order. I will now move on to discuss rent abatements, which is now the next slide. For most tenants who have been negatively impacted by the pandemic and lockdown, rent abatements have been a key target. If tenants can't open, they don't want to be paying for space, or at least they want to be paying less, or at the very least, they want to be deferring payments. Unless tenants have had lease events such as break options or expiry, they haven't really had much leverage to push for outright abatements. As most of you will be aware, given the availability of commercial property at present, landlords are keen to hold on to tenants who may be considering exercising a break option or serving a notice to quit at the end of the lease. However, for those tenants who may have a few years of the term ahead of them without a break option, landlords are perhaps less incentivized to proactively offer rent abatements or other concessions. Most deals we've seen coming through have been at short-term personal concessions to allow abatement for the first lockdown. Unfortunately, this means that subsequent lockdowns since then, and who knows, maybe those still to come, may not be dealt with by the already agreed short-term concessions. It should also be noted that by making concessions personal, that is, just for that particular tenant, and likely in a side letter, means that tenants won't likely be able to pass those concessions on to a subtenant or assignee if the tenant does find a willing party to take over the premises, albeit, of course, I accept that's probably unlikely in current circumstances. Tenants negatively impacted by the pandemic are understandably looking for landlords to be understanding and accommodating, in particular with regards to rent. How we have seen this dealt with varies by landlord, tenant, and geographical location. Some landlords have been particularly on the ball and have standard concessions offered to all tenants throughout their portfolios. There will then, of course, be a negotiation between solicitors of the particular concession wording, but such landlords have taken the decision that it is better to be on the front foot and circulate their preferred concession for negotiation. This then allows the landlord to justify their position on the basis that it is their standard COVID concession offered to all their tenants. These concessions can take various forms, such as back letters, side agreements, or lease variations, and this will depending on the intention of the parties. In order to avoid potential pitfalls, it is important to ensure that heads of terms consider potential eventualities, even if they appear unlikely to materialize. In addition to the importance of considering when any concession or rent abatement should be triggered, it is advisable to consider as widely as possible the future situations that could again require rent abatement. For example, instead of coronavirus or COVID-19 being the triggering or relevant event, consider instead a more general pandemic or infectious disease. The consideration here being, and without wanting to sound too negative, any future pandemics that are unrelated to coronavirus or COVID-19. I will now pass back to Guy, who is going to deal with turnover rent.
Hello again. So, can't trade, don't pay. There's an obvious problem for landlords if their rental income or a significant proportion of it is based on charging tenants a percentage of their turnover. But the tenant can't open for trade. No turnover means, no trade means no turnover, which would mean lower rents being payable. In terms of keep open, this is related to the points that Stuart made earlier about keep open provisions. The pandemic has forced a lot of tenants to look at their turnover provisions more closely. And at the start of the pandemic and before there was a government lockdown, there was some concern about penalty provisions or deemed turnover provisions. Those provisions are the ones that calculate an average turnover under the lease and apply a rate for each day that the tenant closes in breach of their keep open obligations. Where these types of penalty or deemed turnover provisions apply, they'll be linked directly to the keep open obligation. So from a tenant perspective, they'll want permitted closures to be as widely drafted as possible. So that's something to think about when negotiating heads of terms. They want to make sure that these penalties and deemed turnover provisions don't apply in situations where it would be manifestly unfair. Since formal lockdown has kicked in and legislation has been put in place to prevent premises from opening, many of these permitted closure provisions have been triggered as there's a common permitted closure where opening and trading would be unlawful or illegal. There'll be a number of tenants who may wish to close but are permitted to open, for example, small shops selling essential items, or even smaller supermarkets where they're in a city centre location or surrounded by offices in an out-of-town office park or something like that. Their trade will have been significantly decreased and it will have dropped off a cliff in all likelihood. And so the tenant on turnover leases in those circumstances will have to decide what is less costly: closing and taking the hit of deemed turnover or closure penalties, or keeping open and incurring those operating costs despite the low trade. From a landlord perspective, these provisions could be another brutal hit to their income, where tenants are only paying a base rent, or even where some tenants are on turnover only deals. Something to consider when you're looking at turnover rents in terms of the pandemic are changes to the inclusions and exclusions within the turnover definition. Since the start of the pandemic, we've seen a concerted push by landlords to have click and collect trade included within turnover as part of any new deals or concessions being agreed. And while the push to include click and collect sales within turnover had existed before we'd even heard of coronavirus or lockdowns, there's been a real push in the importance of this point as more and more tenants have started to offer a click and collect service, and more of the trade is moving towards that area. So far, we've seen landlords taking a pretty hard line on this, and this type of trade being included within turnover. And it's likely to remain to be a really significant chunk of the tenant's turnover, and so it's understandable why landlords are keen to keep it. The issues that are likely to arise when we look at click and collect are mainly tenants trying to wriggle out of inclusion. Absolutely legitimate for them to be trying to get their best commercial position. And we've seen some great arguments that have been made about it, including well, if it wasn't collected from this store, we would just get it sent from somewhere else. So why include it within the store turnover? Which received a pretty frosty reception, but I like the effort there. Tenants will also argue that where payment is taking place online, that it hasn't gone through their tills in the store, and so it shouldn't be properly attributable to the store, and therefore contribute to turnover rent. From a landlord perspective, they're going to push against that, and they need to be really careful in agreeing any exclusion of click and collect. For example, if tenants install iPads in the store where customers can do an online order and then collect in the store, that same store, either shortly after or immediately, it might technically be a click and collect sale, but that's going to be unacceptable to a landlord in terms of losing that from the turnover calculation, because it's an artificial online sale, because really the premises is there and the stock was there, and that sort of fits into what Stuart was talking about earlier. Another thing to think about here is actually rent reviews. It may not be immediately obvious why turnover provisions and lockdown are linked to rent reviews, but if you have a base rent in a turnover provision that's linked to the previous year's turnover, for example, 80% of it, then the tenants and landlords will want to consider how this will work in the face of a year of closure or mostly closure. So as part of any concession agreement or lease re-gear, we shouldn't ignore the effects of COVID. So what we need to consider is, do we look at the actual turnover for the preceding year? That could produce an artificially low figure. Or do you take an average for the periods of the year that the tenant was open for trade? And this could make a huge distortion in the figures. A good example of where this kicks in is in the case of restaurants who may have had overall a terrible trading year, but if you were to look at the average for turnover for the days that they were open during the year, which mainly was during the Eat Out to Help Out scheme, where Tuesday was like a Saturday, every night was Friday night. The turnover figures for those individual days were massively inflated, and so if you took that as the average throughout the year, then the base rent would be artificially inflated. Some pitfalls to avoid when looking at turnover provision in the context of concessions is that turnover breaks could be accidentally triggered where the tenant couldn't trade. This applies to both the landlord option to break and the tenant option to break in terms of turnover being lower than a certain figure. If you want to avoid the situation where the break is available despite an otherwise viable business and good going trade once things open up again, then any COVID concession should apply, we think, a deemed turnover provision for the purposes just of that break provision, so that what you use either previous trading figures or you ignore the closure periods and look at kind of how trade's been going. It really depends on the nature of the industry that the tenants are in, whether that's going to be appropriate or not, but it's just something to consider. Another thing to think about, and hopefully this isn't an issue too often, is turnover certificates. Just because there hasn't been much turnover doesn't mean that we can ignore turnover certificates or let any return of them to landlords be delayed or anything like that. Tenants, if they don't submit these in time, there's quite often a deemed turnover penalty or a payment to be made. And tenants need to be aware of that, as they could take an unexpected hit to their cash flow, even if most or all of the turnover payment that's made through that might actually be recoverable under the reconciliation provisions. Just something to be aware of. So I'm going to hand back to Stuart now to talk about some government support and insurance.
Thanks very much, Guy. Firstly, just to discuss a bit about rates relief. Retail, hospitality and leisure businesses, as I'm sure we all know, are currently benefiting from 100% rates relief, which is in place until at least the 30th of June 2021. The one pitfall I would flag here is one of tenant reputation. Earlier in the pandemic, we saw all eligible tenants taking advantage of rates relief. When it became apparent that supermarkets had, of course, fared very well compared to other tenants, slowly but surely, one after another, supermarkets took the decision, or most of the supermarkets took the decision, to repay the relief. I thought this was an interesting point, and it will be interesting to see how this develops and if any other tenants who end up in a better situation than expected follow suit and also repay the relief. Turning to look at insurance provisions, in particular in existing leases, it would be expected that in a standard FRI, a tenant would have to obtain insurance and pay the premium, or of course the landlord would obtain insurance with the tenants in a multi-let building, paying the premium through their service charge. The point here to remember is that regardless of any other abatement or concession, the lease term should be understood to ensure that obligations, in particular monetary obligations, are still complied with, whether or not the premises are occupied. The point here being, you may have a rent abatement and service charge abatement, but if insurance premium still needs to be paid, then that shouldn't be overlooked. From the landlord's perspective, if they are required to obtain the insurance, it would be advisable to ensure that they are familiar with the terms of their insurance, and that if required, insurers are notified of any relevant occupancy changes to their property. With regards to business interruption insurance, this may be something that landlord and tenants had in place prior to the pandemic. Much has been in the news recently regarding its applicability and coverage in light of the pandemic, but I just wanted to mention the practical aspects that we have seen. In short, the more likely a landlord or tenant is to require to claim under the insurance policy, unsurprisingly, the more expensive any business interruption insurance policy will be. We are aware of some extortionate premiums being offered, and it will be interesting to see how this develops over the coming months as markets settle and hopefully more clarity on the future returns. Turning to look at government support schemes, we can see how such support can complicate matters between landlords and tenants. This is in the particular context of rent abatements and concessions. For example, if a landlord and tenant have agreed for a rent abatement or reduction or other concession as a result of COVID, and then the tenant receives government support, to what extent should the tenant still be entitled to the landlord's concession? On the one hand, the government support is a lifeline for tenants, but from the landlord's perspective, why should they be taking the hit if the tenant is in receipt of government support when the landlord may not be. On the flip side, how about if a landlord who may have a lender in the background, but that landlord does receive a payment holiday or other support? Should it be the case that tenants should benefit from the landlord's benefit? How can you control or ensure that such landlord support is applied to tenants' rental income, as I suspect most people would agree would be a fair outcome? Such provisions in rent concessions are understandably subject to significant negotiation, with landlords looking to end concessions if the tenant benefits from other support, with tenants looking to ensure that, to the extent that any landlord support does end as a result of government support, that is proportionate to any benefit received. From a practical perspective, we would recommend that when agreeing any concessions, you include as much information as you can with regards to what events would cause the concession to end and what obligations are placed on the parties to ensure that the benefit of any government support, or other support at all, of course, is applied in the relevant manner. Just to sum up today and draw today's session to a close, we have been discussing the considerations to bear in mind when negotiating and documenting concessions. It is clear that there are various pitfalls to be aware of, especially when it comes to trying to deal with the wider impacts of the pandemic on landlords and tenants and how best they can be dealt with in lease documentation going forward. Given the urgency of the situation and the speed at which the commercial property market has had to react to ever-changing circumstances, I don't think it is surprising that there are a multitude of approaches taken from all parties trying their best to get to grips with the situation and consider how the pandemic is going to affect their business. If I could hypothesize for just a moment on how we may see things pan out, I would suggest that pandemic wording may become a much more standard provision in commercial leases over time. In much the same way as the development of insured and uninsured risk has largely replaced the terrorism clauses in commercial leases, we could well see standalone pandemic clauses developing into standard boilerplate clauses in, say, FRI leases. I think what we can be certain of, however, is that the commercial property market has been irreversibly changed as a result of the pandemic. We are fortunate here at Brodie's to be able to advise the widest possible range of commercial property clients, and this truly does allow us a unique and enviable position in the market in being able to keep up to date with industry practice and advising on all developing issues. Guy and I really hope you found today's session useful, and we would now welcome any questions and comments you may have submitted. Our details will also appear on the screen shortly, and we would encourage you to get in touch if you have any more specific questions.
It doesn't look like anybody's actually put anything into the question and answer or into the chat.
Very well.
Bored everybody senseless. Apologies about that. But if there are no questions, then that might well be us about to wrap up.
Thanks very much for joining us.
Thank you very much, everyone.
All right, bye-bye.
Bye.